Welcome to the Business SOS podcast. This is Rich Sierra, president of the Florida Small Business Legal Center. This is episode 146 of the podcast. Thank you for listening and supporting me for the last 1.5 years as we continue our quest for episode 200. So last week I talked about I lost my case, what next? So guess what? We're going to talk about this week. I won my case, what next? So it's kind of a continuing series. There's a winner and a loser, so we're going to talk about winning this time. So you went through your trial and, did not settle a case of mediation. You had presented evidence and you had a great day in court. You had your bench or jury trial. You got a jury verdict. You went ahead and got your verdict on your favor. It was a bench trial, a judge trial. You had a final judgment on your favor as well. You were awarded damages. You're very excited. You won. Now you want to collect money. Okay. So I want to talk to you today about perhaps the reality of what happens when you win, that sometimes it does not mean you're automatically going to collect on those funds, on that final judgment. And there's a somewhat a misconception that when you win in court, you're automatically going to have somebody with a check ready to sign. It does not happen. In most cases, there's appeals. You have to basically chase the people to try to collect. So I want to talk a little bit about that with you. So there's managing expectations that if you're pursuing a case, there's kind of a two-step process. You first have to win your case and get a final judgment. The second part of it is enforcing that judgment and collecting that judgment. And in many cases, it's not that easy. So the first thing is understanding, what you want. You have to read the judge's order, the finding of facts, conclusions of law. Have your attorney explain that to you and explain, okay, what did I win? What is the amount? And usually have monetary damages. You have prejudgment interest. In some cases, you have attorney's fees that are awarded, and those are handled separately from the final judgment as a separate award based on the process that we have to go through to be able to get attorney's fees. So let's say you won, you have your final judgment. Say you got $1 million judgment, just for sake of argument. And so you want to collect. So as I mentioned in the last podcast, now you're a judgment creditor. So you get the final judgment. First thing you want to do, you want to get it recorded in the Florida registry through somebiz.org, and you get it registered. It's already in the court's record and should show up in the public records, but you also want to get recorded. It's only $20 to record the judgment. So it should not be that, it's not a difficult process. It's just online. Your attorney, you can do it. You have to wait a little bit of time to see whether or not they're going to appeal. Let me backtrack a second. You get the final judgment. The judgment debtor now, whoever you won from, what the award you want the lawsuit from, is going to get what is called the form 1.977A or 1.977B, which I talked about last week. That's what is called the fact information sheet. That's very important to you. You want to get that information from them about, they have to provide financial statements, tax returns, bank statements for the last 2 years. You have to any jewelry they own, cars, all the assets, real estate, any asset that they own, they have to list in this form. That will allow you to begin the process of enforcing the judgment and trying to collect from the judgment. The court cannot force people to pay, but the courts can enforce people to provide you the information in that form. And that's very important. So in the final judgment, it says to have 45 days to provide that information. Question that I get, Rich, what happens if they don't provide it? In this case, we go back to court and file a motion to show cause. Ask the court to enter an order to show cause why the judgment debtor should not be held in contempt, because that is part of an order. The judge will give him maybe another 10 or 15 days to complete the form. If they don't, the judge will call him back, will ask for what is called an order of contempt, and in order to purge contempt or to have what is called a writ of attachment. That means arrest. So if they continue defying the court's order and not providing the fact information sheet, we can ask the court to provide additional penalties, including issue an order of arrest to the judgment debtor to be detained and then brought to court the next day and to explain to the judge why the form has not been completed. So there's some enforcements that the courts can do with respect to enforcing the requirement to complete the fact information sheet. But that information is important. You also do not have to wait the 45 days to begin enforcement. You get the final judgment assigned, you can begin enforcement immediately. If you know the bank accounts, you know the assets that you can actually attach, and you have to know which ones you attach, because if it's homestead property, you might not be able to. So it's good to talk to a collections attorney to tell you, okay, this asset, yes, you can attach. This one you cannot. This one is protected. So you have to understand which ones you actually can or cannot do. If the judgment debtor is working full-time at a job, you can garnish a certain amount of their wages. And this is the notice of garnishment is sent to the employer. They're required to garnish those wages and send to you. That's a requirement. If they don't, the employer can pay you, has to pay. Because that's part of a court order. You can garnish bank accounts if you know them. You can garnish safety deposit box. There are certain things you have to be able to enforce the judgment. Anything that is non-exempt property, you can be able to enforce. You'll be able to collect on. You also, as I said before, are able to negotiate if you already know you have a final judgment, say for $1 million. But you know that perhaps the judgment debtor might be able to come up with $500,000. It's a judgment call at that point, whether or not you want to accept less than the judgment to have some money to you now or to continue enforcing the judgment. The piece of paper that has the judgment is only good to you. You convert it to money. Otherwise, it's a piece of paper that has a final judgment that you can enforce. So you have to be practical about this, how fast you can convert that final judgment into funds. So if you cannot come up with a settlement, then you continue enforcing it. Now, what happens if they appeal? What happens if there's an appeal to this final judgment and they file a notice of appeal? You panic, say, oh my God, they're appealing my case. They're filing a notice of appeal. What should we do? That's a consideration, because now what's going to happen is that the judgment debtor is appealing that decision and retain an appellate counsel, or perhaps that attorney is doing the appeal, whichever the case may be, but they're appealing that final judgment to get it reversed for whatever reason. You now have to hire an appellate attorney to help you file what is called the appellant brief, the brief against their appeal. So you'll have to expend additional funds in this case. So there's a calculation to be made. What do I do in this case? They're appealing the decision. Maybe we can negotiate or hire somebody else to fight the appeal. In the meantime, you still can collect. Filing a notice of appeal does not automatically stop collections. It only means that they're filing an appeal. In order for them to stop collections, they have to post a bond with the circuit court of the amount of the judgment. and that will stop collections. As you're secured as a judgment creditor to have a bond there, in the case that the appeal doesn't, you win the appeal, you have the money to collect. Otherwise, you can continue collecting on that judgment while the appeal takes place. So you have a lot of power with as a judgment creditor. You also can issue subpoenas to banks for information, for documents, subpoenas to employers about payroll records. You have a great deal of power to gather information about any assets that this judgment debtor may have. You also can take the deposition of the judgment debtor, the defendant that lost the case. So if the fact information sheet does not give you the full picture of the financial status of this individual or the business, then you can do additional discovery. You can do a request for production of documents, a request for interrogatories as well. And you can actually have them sit down for a deposition and have them go over whatever assets they have, anything that they own, anything that they transferred in the last year. You want to find out what assets were transferred within the last 12 months to see if they were trying to hide money in anticipation of them losing the lawsuit. What major transactions were made. So you have access to all that information to try to collect and determine whether or not they transfer money to somebody else to hide it so you cannot find it. So as a judgment creditor, you have a great deal of power, but you want to be as effective as possible on the collections. Simply because, again, the judgment doesn't do you any good if you're not able to collect. Another option that is out there are companies out there that purchase final judgments. Okay? Again, they're not going to give you the full amount. They're going to give you a highly discounted amount. What happens if you sell the final judgment or assign it to somebody else? That person has the rights. They'll pay you some money, but that person has the right to collect. And there are companies that do that, and you might be able to sell it for a fraction of the cost, but it's better than nothing. Because what happens for enforcement actions, you got to spend more money in some cases. And depending on the amount, there are law firms that do this on a contingency basis. I don't do collections as part of my practice, but I know the law firms that do that based on the amount. That's all they do. And they pursue the judgments and they continue collecting, and then they take a percentage of the amount that they collect. You might be able to put a lien on your property, depending on what type of property it is. You might be able to put a lien on personal property as well, or a business. You have a lot of options as well. The judgment accrues interest daily. So that judgment that you have is an asset that you have now. And it continues to collect interest. And I believe what the interest rate now is, I think it's about 8.98. We just did a final judgment, I believe, yesterday. And it changes. I think the Florida Financial Services website has the interest rates for final judgments that tell you what is the judgment, for the year that you can actually put in final judgments. So it changes every year, but your attorney will know what is the correct amount. The judgments are good for 20 years that you can collect on. So you really have a great deal of power here in continue collecting in that judgment. What happens if the judgment debtor dies? Okay. Now, the estate, you can collect, that judgment can collect against the estate of that individual. So you do have the ability to collect even if the person passes, going after the estate of the debtor. Now, what happens if the debtor files for bankruptcy? In that particular case, you cannot collect anymore. There's an automatic stay. If you get a notice of bankruptcy, suggestion of bankruptcy, or notice of bankruptcy, you cannot continue collecting on that judgment through the circuit court. All collection efforts automatically stops, what is called the automatic stay. If you continue collecting after you receive a notice of bankruptcy, you can have severe penalties by the bankruptcy court. So if you're collecting on a judgment and you receive a notice of bankruptcy, my suggestion is contact your attorney and ask your attorney, what should I do next? In this case, what you would do is file what is called a statement of claim, that you are given a certain period of time to provide that to the bankruptcy court. And there's a meeting of creditors, and you'll be given that information as well. But all collections effort now, anything goes through the bankruptcy court. You cannot collect on your own while this is in bankruptcy. This is very important. You're a judgment creditor. You have the judgment. The judgment debtor files a bankruptcy, whether Chapter 7 liquidation or 13 or 11 for reorganization. In this case, everything stops and everything goes through the bankruptcy court. A couple of things just happen. The debt could be discharged. There's a possibility that you will get nothing if the judgment is discharged by the bankruptcy court. That's a possibility. Or you might get pennies on the dollar. That is an option the judgment debtor has. It's a right that the judgment debtor has. So there's a calculation here to be made, that if you're able to negotiate something to prevent that from happening, that's something to consider, but also something to discuss with your attorney about whether the options. At that point, that becomes a business decision. They say, listen, I give you $200,000. I know it's not the money that you want, but that's all I got, and that's all you have to pay. Or I'm going across the street to bankruptcy court, punching the ticket, you get nothing. So those are the options that you may have depending on the situation. But it's important to know that if the judgment debtor files bankruptcy, their objective is to get that discharged. And at that point, the bankruptcy attorney you might hire will try to fight that in bankruptcy court through the proceedings. That's outside of the scope of this podcast, but there might be options that you have to try to fight that from happening. But remember that the purpose of bankruptcy is to give the debtor a fresh start. So it's going to be really hard pressed to try to get out of that dischargeability for the bankruptcy for the debtor, unless there's a fraud claim that is the reason for the judgment. If there's a reason that you won the case because there was a fraud involved, it is unlikely that the bankruptcy trustee or the bankruptcy court is going to recommend that that particular get discharged because of fraud. So you have to weigh in and find out why you won the case. Number two, is a standard breach of contract case, most likely will get discharged. If it's a fraud claim, probably not. So you have to kind of look at where you are in the situation and determine how to proceed. Obviously, any money you can get up front is better than no money. So you got to use common sense here. As a business owner, you won the case. What can I recover? Can I recover attorney's fees? Depending what the judgment states, you may be able to recover attorney's fees. How do I do that? In that case, your attorney has to file what's, a motion for entitlement of attorney's fees. If it's part of the contract or statutory basis, usually your attorney by now has made that motion to get the entitlement, meaning that the court says, yes, you can have attorney's fees. You just got to come back to me and ask later with more information. In that case, what the attorney has to do is provide statements and to the court, an affidavit of attorney's fees that were expended. Usually there are billing statements involved, there are receipts involved. In many cases, the attorney has to hire a fee expert to testify that the attorney's fees were reasonable, and the expert is testifying they're reasonable for the type of work that was done. And then if the court agrees with that determination, the court then grants attorney's fees. There's a separate judgment. Then you get to start a collection process all over again. So if you're listening to me say, well, it's not that easy to collect the money, it is not. So winning a case in and of itself does not mean that you will collect money automatically. It only means that you have the ability to collect the money once you win. But you need to win the case, get the judgment before you actually go to collections. And that's why I explain to my clients when they say, well, this person breached the contract, once I win the case, I'm going to collect immediately. And I'm like, no, the answer is no. You need to get step 1 first, then you go to step 2. You got to get the judgment first before you can collect. That's essential. We cannot skip steps here. We cannot, skip bases. The key here is to develop a strategy based on common sense and what you're trying to accomplish. Obviously, you want to be made whole. You want your case. You're entitled to collect. How you collect and the amount that you collect depends on a number of different factors. Another option is after you win the case, perhaps go back to mediation and see if you can negotiate something to get something for that judgment. You satisfy the judgment and they give you X number of dollars. There are a lot of different ways to try to get this resolved. If the person is insolvent, has no money, no property, no assets, there's a chance you're not going to collect. And you have to be realistic about that and your expectations, knowing that that is a possibility that you will win. You could win a final judgment and then not collect anything. Just understand that so you have your expectations clear. Don't have this, false impression that by having a judgment, I automatically will get the money. It does not work that way. But you have the ability and a tremendous amount of power as a judgment creditor to enforce that judgment for the next 20 years. So for 20 years, you can continue pursuing this, asking for discovery, asking for supplemental information every 3 months. You can continue doing this until you get paid or 20 years expire. So I just want to share that with you so you make the decision how to proceed with a lawsuit and trying to collect, because you'll have to spend money on the lawsuit to get you to the win, but also you have to spend money in most cases, to try to enforce it. Even though you might be able to get that money back, you still got to spend money to do that. So it's a calculation. There's no clear answer here on how to pursue. Every situation is different. So I'm not here to tell you, okay, go ahead and pursue the lawsuit or pursue collections. Every situation is different. I just want to give you more of a realistic view that just by winning the case, and it's good to be on the winning side. It's great to be on the winning side. Okay, celebrate for one day, then next day, okay, what's next? It's the reality that now you have to go through another process of collecting the money that you won in the lawsuit. So just keep that in mind. And the best advice is ask those questions to your attorney. You're thinking about suing someone. A good question to ask, listen, you know what? What will this cost me to go to trial? Although most cases don't go to trial, but what is the potential expense, worst case scenario, best case scenario? In their analysis, number of witnesses, number of motions, parties, there are different analyses that are done for that. If I win, how collectible is the defendant? I mean, will I be able to get some money at the end? So that is an important decision to make before you go ahead and pursue that lawsuit. knowing very well that in order for you to be able to collect, you have to get the final judgment. So, but it's a good discussion to have with your attorney, so that way you make an informed decision how to move forward with your claim, or whether or not to pursue it at all. And I have situations that the clients have lost hundreds of thousands of dollars, and they're at a difficult crossroads, a very difficult one. Because I said, you have a good case, has great yield potential. I think we have a good chances of prevailing the case based on the information that I have so far. Okay, but I'm not sure what's going to happen after we get the final judgment and the ability to collect. There are a lot of different factors here to consider. But then you have to begin the process of collections after you win your final judgment. So I just want to keep that in mind, that winning the lawsuit, yes, is great. Collecting is it's a process in and of itself that comes with different challenges. It's not impossible. You better be in the collecting side than in the one that you're collecting from. So if you're going to be in one on the side, be in the winning side all the time and be the one that's trying to collect the money versus the one that money's being trying to collect from. So this is the second part of the series. Last week we did I lost my case, what's next? This week I won my case, what's next? So I hope this was good information for you. If you have any questions about any of the topics that I talked to today, send me an email at richsierra.com. Again, it's richsierra.com. If you want to give us a call, my number is 866-842-5202. My website is floridasmallbusinesslegalcenter.com. If you want to see this podcast and video, we're youtube.com/@RichardSierra. Or you can also follow us at FSB Legal and Facebook. Check out my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. Until next week, this is Rich Sierra. I remember that my goal is to help you succeed.